they are the most likely candidates to have standing, but because the federal government's enticing them with added dollars to deal with all of those waivers and extensions, none of them are filing suit. I could file suit, but I'm not gonna have standing because the state of Georgia provides its employees insurance. So I'm not out something as a result of it. I still have state insurance. Actually, I don't take state insurance, but as a state employee, I'm entitled to state insurance. I don't have anything specific. So the idea that the speaker and Congress may have a specific injury because they wrote a bill and the president isn't following the dictates of that bill is a very interesting question, and the one that needs to move up the appellate process. But a lot of the concerns about what the president has done are very, very valid. The problem is finding the party that has standing. Now let me give you the other side of the coin. As Republicans, we don't want judicial activism. As Republicans, we want judges to rule based on the law. That is consistent with restricting who has standing. So the whole idea is a general statement of making sure that only people who have standing, only people that have suffered a specific injury can bring that lawsuit is very much a Republican conservative idea. It, however, creates issues in getting the folks that have the standing. So as I go back to Dodd-Frank that I just talked about, we needed to wait for a community bank to be willing to sue the administration so they would have the standing. And the 11 states joined this community bank from Texas as part of that lawsuit. So a lot of times when you're bringing lawsuits, you have to work on that combination of parties to make sure you have standing. The state of Georgia doesn't have standing. Now, do I have the ability to do an amicus brief or friend of the court brief in support of the speaker? Absolutely. Am I apt to do so? Absolutely. But I can do so as a friend of the court. I can't do so as a party. Virginia.
I would like for you to share with this room what happened with our Attorney General for the United States in regards to his directions to the state Attorney Generals, just in case they don't know. Because I tell you, I appreciate you. I think you are probably the finest person in state government, and you do your job, and I appreciate that. But I would like for you to share with them what instructions he gave to all the Attorney Generals.
Thank you. We meet every March in DC, the national organization. We meet a couple times a year, but our first meeting every year is first or second week in March. And we always invite the Attorney General to talk with us. He is the nation's attorney, so we always hear from him. And during the talk, he literally told us that if there's a law that we don't think is just, we shouldn't defend it. The interesting thing is, you know, there's about 24 Republican attorneys generals. The most, incidentally, we've ever had, literally. And after he gave his talk, it was a very muted applause. Many Democrats were concerned with what he told us. So while you had the Virginias, the Oregons, the Pennsylvanias in his camp, you had a good amount of Democrats that overtly were very uncomfortable with what he said. And I'll give you an example. Our sister state, North Carolina, Roy Cooper is the Attorney General for North Carolina. Roy Cooper is running for governor in 2 years. When North Carolina was sued on their same-sex law, Roy Cooper defended the law. And he took a lot of grief from the Democratic Party in North Carolina for defending the law. And he said, so as a matter of public policy, I don't like the law, but as a matter of being the state's lawyer, it's my obligation to defend the law. So thankfully, we have more Democrat AGs that are in the school of thought that they're supposed to do their job and follow their oath than we have that think they're supposed to pick and choose. But it was very, very startling. I would suggest to you, one of our excellent attorneys general, who unfortunately is not on the ballot this year, is a guy, John Suthers, Suthers. He's from Colorado. He's term limited, so he's not running for re-election. He wrote an op-ed, I believe, in the New York Times or the Washington Post, one of the two, that discussed how it was totally, entirely inappropriate for an attorney general to not defend these laws. It was very, very well worded, and I would suggest to any of you, when you go home today, Google Colorado Attorney General. It's either the New York Times, as I mentioned, or the Washington Post, an excellent column on how it is our job to defend the law. It's not our job to usurp the law for our personal interest or our political interest. So very, very inappropriate. One of the things that's actually interesting is my opponent was in the legislature, voted for the resolution that gave the voters of Georgia the opportunity to pass the constitutional amendment, but about 2 or 3 weeks ago, he first announced he was against the amendment because it now suits him politically for this election. But he actually voted for it when he was in the legislature. So we're seeing a lot of those issues at the moment. And any other questions before Rocky takes the mic away from me? Because I know how forceful he can be. Okay, well, once again, it's my honor to be with you all. I apologize that I'm not talking at the end of your meeting.